Welcome to Term Talk. I'm Beth Wiggins, the Director of the Research Division at the Federal Judicial Center. In this extended edition of Term Talk, we're going to spend about 30 minutes talking about the Supreme Court's most recent administrative law opinions. Joining me today are Erwin Chemerinsky, Dean, and Jesse H. Choper, Distinguished Professor of Law at the University of California, Berkeley School of Law, and Michael McConnell, former judge on the 10th Circuit Court of Appeals, and now Richard and Frances Mallery Professor of Law and Director of the Constitutional Law Center at Stanford University Law School, and also a Senior Fellow at the Hoover Institute. Thank you both for being here.
It's wonderful to be with you.
Thanks for inviting me.
Well, the courts changed the administrative law landscape over the past few terms. This term brought perhaps the most impactful changes with the decisions that overruled Chevron USA, found a right to jury trial when agencies seek civil penalties under some circumstances, and extended the time from which the statute of limitations begins to run in suits against the government under the Administrative Procedures Act. Erwin, why don't we start with Loper Bright Enterprises versus Raimondo, which overturned Chevron deference. First, can you briefly describe the Chevron doctrine?
Sure. It comes from a 1984 Supreme Court case, Chevron USA versus Natural Resource Defense Council. There, the Supreme Court said that if a federal statute is ambiguous and an agency is interpreting it, courts should defer to the agency interpretation so long as it's reasonable. This particular case involved the Environmental Protection Agency interpreting the Clean Air Act. The court prescribed a two-step approach. The first question is, did Congress speak clearly to the issue? If yes, then that ends the analysis. The court follows the congressional intent with regard to the statute. But if the agency is interpreting an ambiguous statute, you then get to the second step, and then the court should defer to the agency's action so long as it was reasonable. This allows agencies to interpret ambiguous terms and apply their expertise to changing circumstances without needing for Congress to act. The reality is the Supreme Court was inconsistent with regard to following Chevron deference, but lower courts took it quite seriously.
So what are the facts in Loper Bright, and how did the Chevron doctrine come into play?
Loper Bright involved a federal statute, the Magnuson-Stevens Fishery and Conservation Management Act. It involves an agency, the National Marine Fisheries Service, which is part of the Department of Commerce. And it adopted rules with regard to certain fishing boats. It required observers be on the fishing boats, here herring boats, and it required the boat owners to pay for those observers in at least some circumstances. And the fishing boats challenged the authority of the agency to require this.
So, Michael, how did the case get to the Supreme Court, and what did the court say?
So this was an adventurous interpretation of the statute. And when it came to the DC Circuit, that court split 2-1, and Chevron deference turned out to be decisive. The Chevron case itself did not actually have this two-step process. The Chevron decision itself was a somewhat more modest case. It was the later development of the Chevron doctrine that became so controversial. And so then it goes to the Supreme Court, and in a 6-3 decision, the court held that Chevron deference is not consistent with the Administrative Procedure Act, separation of powers, basic relationship between judges and the executive.
Justice Thomas and Justice Gorsuch each wrote a concurring opinion. What was the focus of those opinions?
So I think it's easier to see how they differ from the majority opinion, which was focused primarily on the Administrative Procedure Act, which provides that in the case of legal questions, the court will interpret the statute. I mean, one of the bizarre things about the original Chevron decision is that it did not even cite that provision of the Administrative Procedure Act, which is so, central to the case as we now understand it. But Justices Thomas and Gorsuch related emphasized the constitutional separation of powers dimensions of the question rather than the statutory administrative law dimensions of the question. Thus, if their view prevails, Congress probably cannot do anything about this. Not that Congress is likely to do anything about it anyway. And I think that's the primary difference. Now, the majority opinion did not ignore the constitutional and separation of powers issues, but it placed the emphasis elsewhere. The holding of the case, Chevron, was that the agency was not incorrect in interpreting a particular term of the Clean Air Act amendments in a particular way. That holding is good today. The court did not overrule its holding in the Chevron case. Instead, what it did was announced a departure from the methodology that either was applied in that case or at least was attributed to that case by subsequent decisions. And I don't think that the court has ever adequately distinguished for purposes of the theory of stare decisis between overruling decisions and changing its approach methodologically. Chevron was the most often cited decision in administrative law in the last 20 years. So it had a huge stare decisis weight to it. But on the other hand, when the Supreme Court hasn't followed a particular approach for almost a decade, but still expects the lower courts to do that, it's the stare decisis effect is considerably weakened.
Okay. Erwin, Justice Kagan, joined by Justice Sotomayor and in part by Justice Jackson, dissented. And how did they see things differently?
It was a vehement dissent, and I think we're going to say that a lot during our discussion. And it looked at things quite different than the way the majority did and what Michael was just talking about. First, Justice Kagan stressed stare decisis. She said Chevron was decided 40 years ago. It's been the law that courts should defer to agencies when they interpret ambiguous statutes, so long as the interpretation is reasonable. Justice Kagan said if Congress didn't like the Chevron doctrine, Congress could have amended the Administrative Procedures Act to overcome it. The fact that Congress didn't act means we shouldn't overrule it now, the court says. The second thing that Justice Kagan really focused on is Congress. And she said that Congress can't legislate for all specificities and can't foresee everything that's going to happen. That Congress wants the agencies to be able to regulate in these circumstances. She said what Chevron really is a presumption. It's about reasonableness. These kinds of presumptions and reasonable standards exist all the time in the law. And third, she talks about agencies as opposed to courts. Overruling Chevron deference means it's for the court to decide the meaning of the statute without deferring to the agency. She said agencies are much more politically accountable than courts are. So her opinion ultimately was really about separation of powers and how authority should be allocated within the federal government.
Okay. Well, so Michael, what are Loper's takeaways for the lower courts?
I think that this decision is going to have a major impact, but I do not think it's going to be difficult for the lower courts to be able to carry it into effect. I think the bottom line is there are going to be two bottom lines, in my opinion. One is agencies aren't going to win quite so often. And the second point is, I bet, and this is, of course, a speculation, that agency lawyers are going to become more cautious in the future, knowing that they are going to be subjected to, that their statutory interpretation is going to be subjected to a closer look by the courts. They are probably not going to be quite as ready to act on the basis of I call them adventurous interpretations. I think the repeal or the overruling or whatever you want to call it of the Chevron doctrine actually will serve Congress's interests here by making it less likely that agencies go off on tangents of their own without first having the authority of Congress.
If I could just add one thing in terms of the effect on the lower courts. I think we're going to see many more challenges to agency actions in the lower courts. As Michael said, it's going to be easier for the challengers to prevail. Therefore, there's more incentive to bring the challenges. And I think just in terms of quantity of cases, there's going to be a difference for the lower federal courts.
Another case this term we wanted to talk about was Corner Post versus Board of Governors of the Federal Reserve System. Of course, this case extended the time from which the statute of limitation begins to run in suits against the government under the Administrative Procedures Act. It also was a 6-3 decision with the same justices in the majority and dissent. So, Erwin, can you walk us through Corner Post decision and explain the importance of statute of limitations in the context of APA cases?
Sure. Imagine that the agency adopts a rule and that there's a facial challenge to the validity of the rule under the Administrative Procedures Act. When does the statute of limitations begin to run? Does it begin to run when the agency adopts the rule and after 6 years there can't be facial challenges? Or does the statute of limitations begin to run when somebody is injured by the rule, which means that at any point in the future, someone can bring a challenge so long as it's 6 years after the injury? Most of the lower courts had chosen the former. The Supreme Court says it's the latter, that the statute of limitations for a facial challenge begins to run after somebody is injured. It has to be in 6 years of that. Corner Post is a truck stop in a convenience store. It was challenging a 2011 regulation by the Federal Reserve Board that governed the fees that merchants could charge when consumers using debit cards. It didn't even exist, Corner Post, at the time that the regulation was adopted. And the question is, could it bring the challenge within 6 years of when it was injured? The district court chose what I described as the former approach, saying the statute of limitations means has rather than 6 years after the adoption of the rule. The Supreme Court, in a 6-3 decision, reversed. Justice Barrett wrote the opinion for the court. She stressed that the Administrative Procedures Act focused on when somebody is injured, when they're aggrieved. And based on that, she says, the statute of limitations runs from 6 years from when the injury happens, not 6 years after the time the rule is adopted.
So, Michael, can you explain the majority's reasoning and what Justice Kavanaugh's concurring opinion added to it?
The majority, I think, mostly rests upon the proposition that if you have a legally faulty regulation, those who are injured by that have the right at some time to challenge it. And when you have a situation like Corner Post, where the entity didn't even exist, that they simply would have no ability to challenge an illegal regulation. And I think that is really what stuck in the majority's craw. I don't think actually the Kavanaugh opinion adds very much to the decision here. It comments upon a possible implication of the majority decision for a different and really much bigger dispute that has been percolating around the courts and the academy, which has to do with whether a court has the authority to order the vacatur of the entire regulation, as opposed to simply giving relief to the particular party involved. This is a very big, important, and difficult question. And Justice Kavanaugh was saying that if the Corner Post decision is correct, it strongly implies that courts must logically have this vacatur authority. Just one last small point is that Justice Jackson makes, I think, a convincing argument in dissent that that the majority may be painting with too broad a brush. There are different kinds of agency action. Corner Post is a very odd, I don't mean unusual, it happens a lot, but it's a particular kind of injury because Corner Post is not a regulated party under the regulation. They are the beneficiary of a regulation that that controls the conduct of others, in this case, the credit card companies. And so the regulation will never be applied to Corner Post. Corner Post benefits when the regulation is applied to someone else. And it may very well be that the idea of accruing a cause of action should be seen as different in that context than when it is being challenged by the person or entity to whom the regulation is directly applied.
Mm-hmm. So, Erwin, can you tell us a little bit more about the logic of the dissent written by Justice Jackson?
Michael just presented a key part of Justice Jackson's dissent. What I would add to that is she says this is going to have, quote, a staggering effect with regard to federal courts and agencies. She says this leaves all agency regulations unsettled. No matter when the regulation was adopted, it can be challenged now or into the future, so long as in 6 years of the injury. The case came down on the last day of the term, July 1st, and so she referred back to Loper Bright and the other case that we're going to talk about in a moment with regard to agencies. And she said that when you read these cases together, they're going to cause a tsunami of lawsuits and a huge shift from agencies to courts with regard to authority. Again, it was a vehement dissent.
Well, so following that, Erwin, what do you think corner post takeaways for the lower courts are?
Well, just as Justice Jackson predicted, there's going to be more lawsuits in federal court challenging agency rules as being facially invalid under the Administrative Procedures Act. Just common sense explains why. If the 6-year statute of limitations runs from the agency action, it's going to cut off all challenges at that point. But now when the challenge can be brought by anybody who's injured within 6 years of the injury, there's just going to be more lawsuits in federal court under the Administrative Procedures Act challenging agency actions.
So, Michael, would you like to add to that?
Well, just to emphasize that it was already true that as applied challenges to regulations would be brought based upon the time of injury. Perhaps Justice Jackson's tsunami interpretation is going to be true, but it's not obvious that there are that many lawsuits waiting out there. We used to use the metaphor floodgates, and now I guess we use the metaphor tsunami. But whether floodgates or tsunami, these predictions very frequently don't actually come to pass.
Let's move on to SEC versus Jarkesy. With the same 6-3 division, Justice Roberts writes for the majority to uphold the role of the judiciary. Agencies cannot adjudicate and impose civil penalties for fraud or other acts comparable to those that under common law triggered a right to jury trial under the 7th Amendment. The majority distinguished this case from Atlas Roofing, holding that the public rights exception did not apply. So, Erwin, can you tell us more about it?
You stated the issue. Can an agency impose civil penalties for fraud in an administrative proceeding? Or if the agency wants to recover civil penalties for fraud, does that have to go to federal court, or is the possibility of jury trial under the 7th Amendment? It goes to laws that were adopted after the stock market crash in 1929 that regulate securities. A key change was that in 2010, the Dodd-Frank Act made it possible for the Securities and Exchange Commission to pursue civil penalties either in an administrative proceeding or by going to court. This case involved the SEC launching an investigation of George Jarkesy and his business for violating federal securities law. The Securities and Exchange Commission chose to proceed in front of an administrative law judge. The administrative law judge made recommendations. The SEC accepted them and imposed a $300,000 civil penalty against Jarkesy and his company. Other relief was also ordered. Jarkesy and the company appealed to the United States Court of Appeals for the Fifth Circuit. The Fifth Circuit found that what the SEC had done was unconstitutional on several grounds. One of those is what the Supreme Court focused on, is whether it violated the 7th Amendment to have this proceeding in an agency rather than a federal court where there's possibly a jury trial under the 7th Amendment.
So, Michael, what did the court hold and how did they get there?
Well, they held that Jarkesy was entitled, or Jarkesy was entitled to a jury trial on the claim that they had committed fraud. And this goes pretty much to the heart of what the 7th Amendment was about. Why do we have jury trials? The reason is the worry that if it's all an executive, prosecutorial process, that the government will always win because the government, and in this case, the SEC uses its own judges, and lo and behold, when you go before one of the SEC's judges, the SEC tends to win at a much higher rate than if they take it to court. And the problem with this, if there's a problem, maybe this is just an entirely correct decision, but the problem, if there is a problem, is how far does it go? Because this case involves a fraud action, which is a classic both criminal and civil matter. That fraud has been both a crime and a tort for hundreds of years. And suddenly, up until 10 years ago, the SEC brought fraud actions, but they brought them in court, and there would be a jury. And the question is, how far does this go? Does it extend to all fines? So what if, for example, and they exist in so many different regulatory agencies where the fine is for an administrative or regulatory violation that has not been a traditional crime or tort going back. It's hard to see in principle why that should be any different. But if the Jarkesy decision is extended to the full reach of its apparent principle, this much more than Loper Bright or these other cases will upend the regulatory system as we understand it, because ALJs are used in countless statutes and frequently have the power to impose fines on regulated entities for not complying. So I think if this is extended, Congress is going to have to step in and create an entirely new structure for administrating penalties and regulatory statutes.
So, Erwin, how did the dissent's analysis differ from the majority's?
Here it's Justice Sotomayor who wrote a vehement dissent. She said she believes that the majority decision is plainly wrong and unprecedented in American history. As Michael just alluded to, she said, there are dozens of agencies under hundreds of statutory provisions that have been imposing civil penalties. She focused on the public rights doctrine. The public rights doctrine says that when there's a dispute between the United States government and a private individual entity, Congress can assign that dispute to an administrative agency. And the agency doesn't have to provide a jury trial. The Seventh Amendment doesn't apply there. She said that's what the Supreme Court held in the Atlas Roofing case. Ultimately, she says, what this again is a shift of power away from the agencies into the courts. In practical effect, as Michael was saying, it's going to mean so many matters that had previously been handled in the agencies that then were reviewed by the courts now have to be handled in the courts where there's the possibility of a jury trial. I would highlight for the lower court judges some of the questions that are unresolved by this that we've been talking about. First, is this limited to civil penalties for fraud, or does it apply to all civil penalties imposed by an agency, so that any civil penalty would have to go to federal court and have to be potentially tried by a jury? Second, what if an agency operates under a statute that only allows it to impose penalties within the agency? What if the statute doesn't authorize the agency to go to court? Justice Sotomayor gives the example of the Occupational Safety and Health Administration Act, where OSHA can impose civil penalties, but doesn't have the authority to go to court. If it can't impose the penalties and doesn't have the authority to go to court, does that mean that there's no enforcement mechanism? Or will there be implication of the ability to go to court? And third, what does it mean for the public rights doctrine? I've always taught my students, if it's a dispute between the United States and a private party, an individual entity, and it's a civil matter, Congress can assign that to the agency. No longer does that seem true, at least for fraud, and maybe other cases. What's left of the public rights doctrine? All of this is going to be litigated in lower courts and ultimately resolved by the Supreme Court.
Okay. Michael, anything to add to that? I know you've spoken a little bit about it already.
Well, I would just have to say that I think Erwin may have been misleading his students for all these many years, because that's, in my opinion, a way overbroad description of what the public rights doctrine is. It's not any dispute between the government and citizens. It's disputes over matters that where the citizen did not have a life, liberty, or property interest. So that when the government sought to throw somebody in jail or take away their property or limit their liberty, the government had to go through certain processes. But if, for example, the government, there was a question: were they entitled to certain, welfare benefits, or what about the right to get a patent on federal land to occupy the land, or what about an employment dispute between an employee of the government and so forth? There are any number of disputes that do not touch upon people's life, liberty, and property. And all of those, that I thought was at least that's what I've taught my students, is that that's what the public rights doctrine is all about. The thing about Jarkesy is that to impose a fine on someone for disobedience to the law looks like it's on the private side rather than the public rights side of that divide.
I think it's crucial. I've never suggested that criminal matters could be put in an agency. But with regard to civil matters, courts have been very broad in interpreting the public rights doctrine. And I agree with Justice Sotomayor here. This limit on it is unprecedented.
Okay. Well, let's step back for a minute. Michael, as you know, there have been a number of substantial changes to the administrative state over the past few terms, not just this term. So taken together, where are we now and what are the implications for the lower courts?
Well, these cases are not going to be the end of the matter. The regulatory state, love it or leave or hate it, has been, with us for decades, but was constructed in many ways which are very difficult to square with the way in which the text of the Constitution is written. But for many of those years, the courts were very inclined simply to defer to what Congress and the agencies were doing. We now have some justices on the court who are less inclined to defer, who are inclined to say, look, if people are entitled to jury trials before they can be punished for legal violations, well, that's what the Constitution means. Let's do it. And so I also think that this is going to relates to the non-delegation doctrine in a way, which is whether it's a doctrine or not, who knows, but the idea that Congress can't just leave to delegate to the executive branch vast undefined powers, but Congress itself has to legislate. I think that many of the recent cases are designed to make the non-delegation doctrine matter less by making sure in the first instance that at least Congress intended to empower the agency to act in a particular way. Whether Congress's own authority should be limited is one question, but it is I think, a pretty fundamental bedrock of our system that the executive branch can't act without authority from Congress, and it shouldn't be able to conjure up claims of authority by, say, vague interpretations of or expansive interpretations of vague statutes.
I
Erwin?
point to two things. First, I think there's a major shift in authority in all of these cases from agencies to courts. In the 2 terms prior to this, the Supreme Court created a new doctrine, the major questions doctrine, that said that an agency cannot act on a major question of economic or political significance without clear guidance from Congress. And there are dozens, maybe hundreds of cases now in the lower courts trying to clarify what's a major question of economic and political significance, what's enough congressional guidance. But it gives courts a new tool to strike down agency actions. All 3 cases that we've discussed in this conversation involve a shift of authority from agencies to courts. And so in terms of practical effects on the district courts and the courts of appeals, that's what I'd emphasize. But second, I think something larger is going on. Since at least the Administrative Procedures Act, and probably since the New Deal, there's an assumption that we need to have federal agencies empowered by broad delegations of power who use their expertise to then govern within their statutory authority. And courts should defer to the expertise of agencies. I think the conservative justices on the court are questioning all of those premises. The need or desirability of broad delegations of power, the idea of agency expertise, the need for courts to defer to that. The liberal justices are expressing such anger in their dissents because they still believe those premises of the administrative state that the conservative majority is no longer accepting.
Well, thank you both, and for the discussion of this year's cases, as well as delving into the past a little bit. Thank you very much.
Thank you.
Thank you so much.